submit only on those issues. I hope I'm clear. And we don't expect debate on these. We expect compliance. I thank you very much, CJ. I thank you, Council. And remember, CJ, and Council, this exercise must be conducted before 2 p.m. tomorrow. What will be undone by tomorrow will be undone. I thank you.
Thank you, Justice Renaura.
My lady, the Chief Justice and members of the court, we are also having difficulties with the orders relating to inspection of the servers. We have been given restricted access only to the result transmission system, and only it has not been granted yet, only to one server. And it is established that the IBC has got 8 servers. We have taken the decision to write formally to the registrar in the hope that the court eventually can resolve this matter as quickly as possible, because we are running out of time. But there's no compliance in terms of the orders that the court gave.
We are aware about that issue. We are following up on the question, and as far as we know, the exercise is continuing. Should there be an issue later in the day or tomorrow morning, we shall receive a report. But as far as we know, by the time we got out of here, the exercise had commenced. There was an agreement on how to access the server that was given, and the issue of cloning is being addressed. So let's leave it for now. Let's report again tomorrow morning. I thank you, CJ. I thank you, Mr. Orengo. We are aware about that issue.
May I, with your very kind permission, Madam Chief Justice, I would like to rectify a mistake. We intimated to you yesterday that the 2 commissioners, Professor Guleye and Boya Molu, would have separate representation. That has been achieved, and we have Dr. Willie Mutumbwa, who is in court, and we have for Mr. Professor Guleye and Mr. Peter Wanyama for Commissioner Molu. Thank you.
Okay. That is noted. We can now proceed to invite counsel for petitioner in petition number E002 of 2022.
Thank you very much, Your Ladyship, the Chief Justice, members of the court. I wish to make submissions this afternoon before you on behalf of the 3rd petitioners in the consolidated petition. The petition filed by the 3rd petitioner, initially as petition number 2 of 2022, raises or has issues that deal with all the issues that had been framed all 9 issues that had been framed for determination by the court. But in respect of issues number 1, 2, 3, 4, 5, and 6, I will rely on the written submissions that we have filed or that have been filed on behalf of the 3rd petitioner, and I will utilize my time on my feet this afternoon to focus on issue number 6, the conjoined issue number 7, number 8, and number 9 of the issues that the court framed or the court has framed for determination. I wish to get straight into issue number 6. And my humble understanding of issue number 6, and I will read it just for clarity, whether the IEBC has carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 138(10) of the Constitution. Again, it is my humble understanding from the manner in which that issue is phrased that what the court is inquiring into is not whether tallying and verification should be done in accordance with Article 138(3)(c) and 138(10), but indeed whether tallying was carried out, by Article 138(3)(c)(10), 3C and 138(10) by the IEBC. Time was taken by my learned senior colleague, Mr. Paul Mwangi, earlier on this morning, to make submissions as to what the IEBC is, the meaning and definition of the IEBC, and what amounts or what body or group of people then amount to the IEBC. And that is a submission of law, and I don't intend to repeat the submissions that were made by my learned senior colleague. But the issue as framed in number 6 invites a detailed factual inquiry. And that factual inquiry is the factual question of, was the tallying and verification during the or after the presidential election that is the subject of these petitions indeed carried out by the IEBC? I wish to start my submissions by referring you to a press statement. And that press statement is by the chairman of the IEBC. I believe he's the second respondent. That press statement is dated the 17th of August 2022, and that press statement is to be found in volume 4 of the third petitioner's documents at pages 493 to 496. That press statement is dated the 17th of August. It is headed, the subject is staff murder, profiling, and misleading reports on the presidential election. It is under the hand of the chairman of the IEBC, and it is divided into 3 parts. I wish to focus my submissions on part 3. And part 3 is headed Declaration of Presidential Results. And I submit that this press statement is important because it is the first account by the second respondent as to how tallying and verification took place. In line 12, he states, for the avoidance of doubt, the law provides that the chairperson of the commission is the returning officer of the presidential election. I will emphasize on that the chairperson of the commission is the returning officer of the presidential election. I will make submissions later on in my submissions, and I will hope to persuade you that there is no such position as the returning officer of the presidential election. It is a creation of the chairperson of the IEBC, and it is created for the purposes of executing a very calculated scheme. Be that as it may, I wish you to then go on to the second paragraph from the end at line 34, where he says, as per Article 86C of the Constitution of Kenya, the results from the polling stations are openly and accurately collated and promptly announced by the returning officer. The next sentence is important. It is also important to note that Regulation 87 of the Election General Regulations provides, and he then goes on to state, that he, as the chairperson, is the one who is then empowered to tally or to verify and tally the results. Again, later on on page 495, he goes on to state, this constitutional mandate, and he's talking about the mandate to tally and verify, this constitutional mandate falls squarely on the chairman of the commission, who is the national returning officer. Again, he repeats that, as gazetted in Gazette Notice number 4956 of the 28th of April 2022. The role of the national returning officer for the presidential election is not a shared responsibility and not subject to plenary discussion of the commission. Very important, because at the end of the day, this is how the second respondent then tallied, verified, and declared the results, but we will get to that later on. He states in the paragraph beginning as the gazetted national returning officer that in the spirit of teamwork, the chairperson involved the commissioners. That is all he did. In the spirit of teamwork, he felt that there was no duty to involve them. All he did was involve the commissioners. And again, later on during my submissions, I will get to that. My learned senior colleagues who submitted before me dwelt in detail on the content of Regulation 83. The content of Regulation 83.2 and Regulation 87.3.1, Regulation 87.3 in its entirety, and the manner in which those two regulations enable the chairperson singularly to tally or to verify and tally results in the presidential election. I do not wish to take any time to go through those two regulations, merely to state that it is my humble and respectful position that those two regulations are inconsistent with the provisions of Article 138(3)(c) of the Constitution, because they enable the result in the presidential election to be verified and tallied in a manner other than envisaged by the Constitution. There is a substantive prayer in the petition to declare those two regulations unconstitutional. And I state for that reason that relief should be granted. Later on in my submissions, I will then make submissions as to the consequence of those regulations being unconstitutional and having then hopefully being declared unconstitutional by this court. The fact that the tallying and verification of the result in the presidential election was done solely by the chairman is laid bare in the provisions of Gazette Notice number 9540 of 8th of August 2022. This again was referred to by my learned senior colleague, Mr. Firoz Noroji, whilst he's on his feet. And this Gazette Notice is to be found at page 36 of the affidavit sworn by the second respondent and drawn by the firm of my good and learned friend, Mr. Eric Gumbo and Associates, at page 36 of that affidavit. Mr. Noroji took the court through that affidavit extensively, through that Gazette Notice extensively. I only want to emphasize that before the election, the chairman of the commission is clear that it is he who will tally, who will verify and tally the results. And for some reason, the chairman the chairman of the IEBC had the propensity to publish Gazette Notices even where he didn't need to, because there was no need, there is no statutory basis or regulatory basis or even constitutional basis for gazetting the result pathway. But he went ahead and did it. And it is clear, and I submit it is admitted by the chairman of the IEBC that he exclusively, to the exclusion of the rest of the commissioners of the IEBC, tallied and verified the result for the presidential election. So as to determine conclusively that the tallying and verification was done exclusively by the chairman, it is again important to ask the question, where were the other commissioners? Where was the rest of the IEBC as the chairman was tallying and verifying the results? Again, I wish to refer you to the same affidavit that I have, the affidavit sworn by the chairman and drawn by the firm of G&A Advocates on the 26th of August this year. And it starts from the second paragraph. He states in the second paragraph that in my capacity as the chairperson of the commission, I was the returning officer of the presidential election. He then goes on later on in the affidavit at paragraph 45 to state that for the proper management of roles at the tallying center of the presidential elections, I had designated in writing specific roles to each of the commissioners and other commission staff. Annexed here to as WWC 9 is a bundle containing the said communication. Again, this bundle and this communication is important, members of the court, because it states clearly what the other commissioners or the roles that the chairman had designated the other commissioners to do. At page 41, there is an internal memo or a letter signed by the chairman on the 22nd of July, addressed to the vice chairperson Juliana Cherere and Commissioner Boya Molu. And it is headed Appointment to the Media and Call Center Management Team for the Presidential Tallying Center, Bomas of Kenya. And he goes on, he says, consequently, you are hereby appointed to the Media and Incident Reporting Team of the Presidential Election Tallying Center as follows. Juliana Cherere, Team Leader. Commissioner Boya Molu, Alternate Team Leader. And their roles are set out there. Terms of reference of your appointment provide liaison between the Presidential Returning Officer, who is himself, and the National Communication Center, preparing periodic briefs for the Presidential Returning Officer to address the media, briefing the Presidential Returning Officer on electoral activities across the country. Nothing to do with tallying and verification. The two subjects of that letter are commissioners of the IBC. The next letter is on page 42, also dated the 22nd of July. This one is addressed to Commissioner Francis Wanderi and Commissioner Irene Masit. Again, under the hand of the chairman, and it is appointment to the Logistics, Welfare and Security Team at the Presidential Tally Center, Bomas of Kenya. Again, he appoints them in the second paragraph. Consequently, you are hereby appointed to oversight, provide policy direction and strategy formulation for the Welfare and Security Team of the Presidential Election Tallying Center. He then states their names and he states their terms of reference as security of the Tally Center and installations, the Tallying Center's logistics, planning and organization, security of members of the commission, staff, VIPs and other visitors, transport for commission staff, any other duties assigned. Important, those are two commissioners. None of them has been assigned to tally and verify. The third letter is on page 43, and this one is addressed to Commissioner Justus Nyang'aya. Again, Justus Nyang'aya is appointed to be in charge of dignitaries and protocol. And in the second paragraph, he is told that as team leader for dignitaries and protocol, he will be responsible for providing support services to the commission, managing protocol of dignitaries and VIPs, managing access to the Presidential Tally Center for accreditation, for accredited media, observers and agents, and any other responsibility. Now, those are out of 6 commissioners. Those are 5 commissioners. None of them is assigned to tallying and verification. There is a last letter, also dated the 22nd of July on page 44. This one is addressed to Commissioner Professor Abdi Guliye and Mr. Marjan Hussein Marjan. I wish to point out to this court and ask the court to note that Marjan Hussein Marjan is not a commissioner, but he is merely the CEO of the IBC. Now, these two are appointed to the results management team at the Presidential Tally Center. Their duties are undertaking quality assurance of result forms received from the Presidential Returning Office desk, tallying and processing of election results. I urge that that is the language of Article 183.3, and assisting the Presidential Returning Officer in managing a record of the election results. Tallying and verification, I submit, on the admission of the chairman of the IEBC was done by Professor Abdi Guliye and Marjan Hussein Marjan, and not by the IEBC. The tallying process continues unconstitutionally as it was being conducted, and I want to pose the question and attempt an answer to the question, how does that process then end? That process ends as set out in paragraphs, again, the same affidavit of the chairman, at paragraph 76 onwards. But the story that he tells, or the deposition that he makes, starts in paragraph 66. And I will read it because it is important. He deposed, shortly after 2 p.m., the commissioners and I had a meeting to be briefed on the final result by the commission secretary, stroke CEO, an alternate leader of the Tally Center. The meeting was only for a briefing. He then goes on to say, the briefing was to be done before my declaration in accordance with Article 138(10) of the Constitution. So according to the chairman, all that was going to take place between him and the commissioners was a briefing, and he then goes on and declares the results. What did he do? After he narrates the story of the visit between paragraph 67 and 75, he then goes on under the substantive heading, Commission Briefing of Final Results. After the NSAC team had left, the Commission Secretary and Chief Executive Officer, who was also the alternate leader of the team of the Tallying Center, Mr. Marjan Hussein Marjan, walked into the boardroom. The purpose of the meeting was to receive the final tally of results of the presidential election before I could proceed to declare. From the chairman's own evidence, he assembles a team that comprises Professor Gulie and Mr. Marjan. They tally and verify the result, and Mr. Marjan is merely coming to brief the commission. What happens after that? There is between paragraph 77, where he states that copies of the results were handed to the commissioners, and that is all that was done. The result had been tallied and verified elsewhere. The copies are merely handed. There is a conversation. There is no agreement. And of importance, at paragraph 81, the chairman deposed as follows. I walked out of the meeting room accompanied by Commissioner Professor Gulie, Commissioner Molu, and the Chief Executive Officer. And he then went to the auditorium and declared the results. In the chairman's own words, and I submit that his narrative of what took place is important. That is how the tallying and verification of the result in the presidential election took place. To answer or to attempt an answer to the question that is sought by this court by framing ground number 6 as it is, whether IBC carried out verification, tallying, and declaration of the results in accordance with Article 138(3)(c) and 138(10), I would answer that question in the negative. Tallying was carried out by the chairman alone. At best, the chairman, Professor Gulie, and Mr. Marjan. A quick look at Section 5.1 of the IEBC Act would disclose that those 3 gentlemen, however eminent, are not the IEBC. What the Constitution enables the chairman to do on his own is to declare the result. I submit that the election is a process, it is a progressive process, and the completion of one process enables another. If you do not complete voting, you cannot tally. If you don't complete tallying, you cannot declare. I submit that tallying and verification, having not taken place as provided by the Constitution, then there was no result for the chairman to declare. There is an attempted justification by the chairman for his decision to tally and verify the result on his own. That justification exists in an affidavit sworn by the chairman. This time it is drawn by the firm of Iseme Kamau and Maema Advocates. It is at page 14, at paragraph 62. The chairman attempts to justify his decision to tally and verify alone from this court's decision in Raila 2017. with tremendous respect to the chairman, the issue of his ability to tally and verify on his own was not an issue in Raila 2017. And with the clear provisions of the Constitution, in Article 138(3)(c), there can be no judicial foundation for the chairman's tallying and verification on his own. At the beginning of my submissions, I had submitted that I wish to demonstrate to this court that the chairman executed a very well calculated scheme to grab the election and to run the election on his own. And this is how, in my estimation, he did it. Elections are normally commenced by a notice of elections that is issued under Section 14 of the Elections Act. Regulation 12 of the Elections General Regulations then provide that certain specific notices will be issued for the presidential election. Regulation 12.2 provides as follows: immediately after the publication of a notice under Section 14, and the notice under Section 14 of the Act is published by the Commission, the returning officer of every constituency shall notify the holding of a presidential election in Form 8. Now that's important, because I had also said that earlier on that there is no such role as a presidential returning officer or national returning officer. And I say so because of the provisions of Article 138(2) of the Constitution. Article 138(2) of the Constitution says, if two or more candidates for president are nominated, an election shall be held in each constituency. An election shall be held in each constituency. A returning officer is defined in Section 2 of the Elections Act as a person who conducts an election. The chairman is merely enabled to declare. The conduct of the election by dint of Article 138(2) is by 290 returning officers. The notice that they were required to publish under Regulation 12(2) was never published. The 290 notices from the 290 returning officers was never published. There is no position like the national returning officer. So the first infraction is that there are no notices. The chairman constitutes himself as the national returning officer, and the notices are not published. The chairman gazetted himself. I believe the gazette notice is the gazette notice, I think it is the 22nd or 28th of May. He gazetted himself as the national returning officer. As a matter of good electoral practice, returning officers are gazetted with deputies. The chairman gazetted himself with no deputy. It was his election to run as he saw fit. There is the issue of the deployment or the unilateral transfer of returning officers. My learned colleagues who appear for the commissioners have dealt with that extensively in their affidavits, and I'm sure they will submit on it when they have their time on their feet. Again, the deployment of commissioners at Bomas was not accidental, it was deliberate, it is documented, and the details are spelled out, the duties are spelled out in detail. Again, the postponement of the elections is another issue. And I wish to pose this question at this juncture. We have interpreted constitutional time as being strict, but the chairman of the IEBC has on more than one occasion dealt with constitutional time as if it is elastic. The elections that he postponed on the 8th of August were not the first elections that he postponed. In the second week of March 2000, the then sitting MP for a constituency in Kwale called Msambweni passed away. The Constitution provided that by-election be held within 90 days. That by-election was not held until the 20th of December 2000, or not 2020. Again, that is another election that was postponed, and it just went by. The manner in which the commission conducted itself, or the chairman conducted himself, around the commission dealing with these very petitions is also instructive in the manner in which the chairman had assumed certain roles and capacities to himself. I wish to refer to the affidavit of Juliana Cherere, filed in this court on the 26th of August. And I wish to refer members of the court to the to annexure JC12. That annexure is correspondence, it is internal memos within the commission. The first one is signed by the 4 commissioners, and it is a request for a special meeting whose agenda is to deliberate the commission's position in light of the presidential elections petition filed in court on the 22nd of August. That letter is dated the 24th of August, 2 days after the petition is filed. Annexure JC12 or JC13 is a follow-up to that letter. There is no response, or there is no response by the chairman to the initial memo, and there is a follow-up now asking for a meeting on Friday the 26th at 9 a.m. at the commission's offices to discuss that purpose. Of tremendous importance is the letter, or is the internal memo exhibited as JC14. This is a response to the request for a meeting. This one is not under the hand of the chairman, but under the hand of the CEO, where he convenes that meeting for today, the 31st, the first day of hearing. Is that a chairman acting in the best interest of the commission? Is that a chairman acting constitutionally responsibly? The effect of the unconstitutionality in the election was dealt with by this court's decision in Joho 2014. Anything done under that unconstitutional piece of legislation is a nullity. In the brief time that I have left to answer the ground number 7, it is impossible to tell whether the returned candidate garnered 50% plus 1, because the process by which that finding would have been made did not take place constitutionally. The election having been conducted as it was, there is no result. The votes that were cast by the people of Kenya having not been properly tallied and verified, or verified and tallied, there can be no declaration. I wish to assert the submission made by my learned senior colleagues that an election is a sovereign process that belongs to all Kenyans. And via the Constitution, we have delegated the management of that sovereign process to the IEBC. It was a constitutional infraction of monumental proportions for the chairman to seize the election as he did. And for those reasons, it is my humble request that all the prayers that are sought in petition number 2 of 2022 be granted.
Thank you, Council. Next. Yes.
If may please, my lords and my ladies, I start by saying that election is a process. I'm Otieno Willis, appearing for petitioner number 4. Election is a process that ends upon the determination of the true wish of the voter. And when that process is unconstitutional, it is not enough to throw numbers that are arrived at through an unconstitutional way to assert that that is the true will of the voter. The first issue I wish to address, my lords and my ladies, is issue number 6. And issue number 6, core to it, is Article 138(3)(c) of the Constitution, which vests upon the IEBC the duty to tally and verify results from all polling stations and to declare the result. I want the court to take note of the last part of Article 138(3)(c). The IEBC shall tally and verify the count and declare the result, not the results. Results is the numbers. Result, without an S, is the outcome. And I want the court to notice that 138(3)(c) is a responsibility on the commission, not on the chairman. So the first declaration of the result of the verified and the tallied counts is made by IEBC as a commission. Then the chairperson, again, the word of the Constitution used is the chairperson in Article 138(10) shall now proceed to formally declare the results and issue the certificate. My Lord and my ladies, Article 138(3) sets out a 4-tier process. Tier 1 is the polling station. Tier 2 is the constituency. Tier 3 is the National Tallying Center, in brackets, IEBC Commission. And Tier 4 is the chairperson. Tier 2 cannot function without Tier 1. A constituency cannot function if polling fails at the polling station. A returning officer cannot go to a polling station and make a declaration of the results of that polling station. It's not his function. The IEBC as a commission cannot go to a constituency and fill Form 34B for a particular constituency. If they do so, they failed it. Similarly, the chairperson cannot move from Tier 4 and go to Tier 3 and purport to verify and tally the votes, the counts, and make a declaration. Each tier must perform its function. It is now tried that under Article 81, elections must be conducted by an independent body. The presidential elections whose results we are disputing were conducted by an independent individual, not a body. Because if it was a body, I would not have been served with documents from commissioners confirming they did not participate in the verification and tallying of the count. A majority of the commissioners, IEBC in their replying affidavits served upon me, has confirmed they did not tally and verify those results. My lords and my ladies, I wish to state, Chapter 15 of our Constitution establishes constitutional commissions and independent offices. Where the Constitution desired a function to be performed by an individual, it established an independent office. The Office of Auditor General, the Office of Controller of Budget. But where it desired a function to be performed by a commission, it established an independent commission. The Office of Election Management Body is a commission. It is not established as a chief elections officer as an independent office, as Wafula Chebukati seeks to run the commission. My lords, if the people of Kenya desired to have an individual, they would have simply reverted back to 1988 when we had a supervisor of elections. I will not go back into what has been submitted, but only to add on that point that where a commission has been properly constituted and the number is set as an odd number, the Constitution and the law presupposes there may be dissent. And the oddity of the number is to make sure that ultimately a decision will be arrived at. In this particular case, the oddity of the numbers led to a decision of the commission. And a majority of those commissioners have told us in their affidavits that they did not carry out a tally and verification of the results. Tier 3 failed. Confirmed. Let us go to the state of mind of Mr. Wafula Chebukati on the 15th when he was conducting this function, just to confirm to you that he did it himself. In page 12 of volume 1 of my documents is a statement dated 17th of August by Wafula Chebukati, in which he says that it was his sole responsibility and that the commissioners had no role in that process. That was his state of mind. But the same person, when he comes to court in his replying affidavit, at paragraph 75, 76, 84, 85, he turns around and says, the commission in a collegiate manner arrived at a decision. Why is he lying? If on the 17th he has told us it was his sole responsibility. When he comes to court now, he says the verification was done by everybody. And it's important that I point out in the replying affidavit by William Ruto at paragraph 16 and 17, he also says that it is the sole responsibility of the chairperson to verify and to tally the results. That was their state of mind. But we are submitting it is not the law. The law is everybody must conduct it. These issues which we are raising were canvassed in the Maina Kiai case. Hele Khalifa, the petitioner number 1 in this petition, was a petitioner there. And the court said the IEBC, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for the election of president, electronically transmitted to it from the near 40,000 polling stations, is required to tally and verify the results received. That was the law in Maina Kiai. And they go further to say the architecture of our laws is that the power to tally and verify cannot be vested in an individual. Supreme Court Raila Odinga 2017, the court said in paragraph 292, the failure by the first respondent to verify the results in consultation with the second respondent, IEBC and the chairman, failing to act together in concert, meant that it went against Article 138(3)(c). That was binding. To drive this point home, my lords and my ladies, taking into account those two decisions, the number of IEBC commissioners are 7 plus the chairperson. The number of Supreme Court judges are 7 plus the Chief Justice. If, as has been...
Counsel,
yes.
Do I understand you to be comparing the Supreme Court, its architecture, and the IEBC?
No. I wanted to give an example.
Be careful, Counsel.
Okay, I'll try to be very careful. I'll try to be very careful and not extreme. I just use the number of 7. That in terms of 7, the Supreme Court sits as a full bench when constituted. And the rules on arriving at a decision is by majority. And there have been even instances when the Chief Justice of this court has been on a minority. And we never saw a Chief Justice walking out there saying, my minority decision is the decision of the Supreme Court of Kenya. In the instance petition, we have the chairman and Gulie and Mr. Molu walking out saying, our minority decision is the decision of the IEBC. How absurd can it be? And to buttress that point, Mr. Nyamodi has clarified what roles were given to the commissioners as opposed to tallying. The roles given, for example, to judges are known to adjudicate over matters. If it were to happen, and I know it can never happen, that the Chief Justice assigns judges some to go and receive advocates, some to go and receive VIPs, some to go and receive the media. Then the Chief Justice remains with only 2 other judges, and they make a decision and tell the people of Kenya, this is the decision of the Supreme Court of Kenya. How absurd will it be? That is what transpired in this particular case. Commissioners were relegated outside their core functions, and the function performed by an individual, what I call a minority of the IEBC. That was never the intention of the law. On the technological aspect, as I move to summarize, I want to refer, my lords and my ladies, that's issue number 1, on the qualitative test of the technology. IEBC, under the Elections General Technology Regulations, conducted an independent audit of the biometric voter register. This is what your auditors said at page 32, volume 1 of my bundle of documents. The KPMG report found that 481,711 persons were not qualified to be on the register, but they were on the register. Duplicates. One person has several entries. If this number was below the margin of victory, it will be insignificant. The start of an election process is the voter register. It must be a very clean document. In this case, they started the race with a register by their own audit as at the 16th of June. The register that was gazetted on the 20th of June, that register had 481,711 persons who were not supposed to be there. Duplicates, several entries. The margin of victory by which William Ruto passes 50% plus 1 is less than 70,000 within this margin. The margin of victory by which is declared more than Raila Odinga, 200,000, again less than this. So the universe of the elections was already compromised ab initio, and the number by which it is compromised could affect and did affect the results. To use my Supreme Court example, I will say, if all the judges were biometrically registered, we know there are 7 judges, but we go a biometrics audit, we find there are 9 voters in that register. Would we say that that register is authentic if they were to vote on an issue, and then the return is 4-3, and yet the register had 9 people? Would we say that only those who are legitimately qualified to vote participated? I would say not. In page 36 of my volume 1, the audit report finds that 638,814 entries were noted to be null IDs. You have registered voters on the register who don't have ID numbers. Null. That is the quality of your election document. And at page 37, the auditors find that there are generic users who cannot be attached to anyone, generic users of the biometric voter register system who cannot be attributed to anyone. But more importantly, the auditors found that there were 14 non-returning officers, users, accounts that had been granted access, voter access privileges on the identity data management system. Non-users, some of them are referred to as Embakasi South clerks. People who had access to the system, and they were able to make changes on the persons who are supposed to be on the register. Non-authorized users, their own document. At page 39, audit report finds that there are users who are not gazetted returning officers that have access to the database. It is important that we note this. Page 42, IBC's response to the audit queries. They said it was not humanly possible within the time available to deduplicate the register. That is, to remove those erroneous entries. So they are confirming they went into an election in which the register was compromised, and the number by which it is compromised could and did affect the results. They also purport to say that they cleaned the unauthorized users. At the time when they're doing it, your system has been compromised. There's nothing left to say. You are now running on autopilot, as the KPMG audit report says. The horse has bolted. The stable is broken. My lords and my ladies, it is my submission that when you look at the systemic issues arising and affecting the integrity of this election, should we even pay attention to the numbers which we are now being fronted? If the system was compromised from the beginning, the universe of the elections had been compromised from the beginning, that whatever numbers will come out of that universe of the elections, the voter register, does not matter. And I do believe even the third respondent, if he was the one filing this petition, would raise the same issues that I am raising today. What should we do in regard, in terms of my reliefs? I urge my lords and my ladies, the problems of IEBC, and specifically the second respondent, are systemic, as I've said. The court should consider the conduct of this second respondent, Wafula Chebukati, and Professor Gulie and Mr. Molu. The common constant, they were the only commissioners who were in the 2017 general elections. They are the only commissioners who procured the elections technology. And they are the only commissioners again today who are dissenting. They are the minority commissioners who are trying to countermand a decision of the commission. Appropriate sanctions need to arise. In light of the disobedience of the court orders in Maina Kiai, the court was very emphatic on what is the role of IEBC and what is the role of the chairperson. Very clear. When he unilaterally ignores that court order, I urge this court to take that into account when making appropriate sanctions. When the same person in 2017, again, refused to accede to the orders of this honorable court in Petition 1 of 2017, this court should take that into account. We can't be coming back to you every election with the same problem involving the same person. It is time that Mr. Chebukati is shown that the will of the people of Kenya is supreme, and he must work within the constitution and decisions by these courts. That's why we are calling for criminal sanctions and appropriate reports to the DPP. Why should the people suffer constant anxiety around elections that are being bungled when the courts have sounded themselves hoarse and loud on what is your role, what are you supposed to do, what technology to deploy, how to protect that technology, and is not doing it? If you look at we've attached the PSC report, Public Accounts Committee reports, again, finds an indictment of the same person sitting in meetings where he's conflicted. Look at the KPMG report. The auditors are saying they are being given even the information requested so late in the day, on the 16th of June, for a register to be gazetted on the 20th of June. This was deliberate attempt to make sure that the election is compromised. Section 6 of the Elections Act required the register to be opened for inspection 90 days before the date, the notice of a general election. The notice came out on the 20th of January. The register ought to have been opened 90 days before the 20th of January for inspection. He didn't do it. He gave the auditors the report so late, but they still pointed out that your register has a problem, and he took no remedial action. he proceeded to conduct the elections in the way that he desired. What he ended up doing is what my grandmother, Sophia Magambo, calls Nairobi Karafu, pata potea. Nairobi Karafu to mean at the National Tallying Center. It is, and we've averted on our affidavit, the national person of the commission called both Raila Odinga and William Ruto. The whole day, nobody knew who the winner was. Even the commissioners didn't know the results because tallying had stopped. I refer to the affidavit of the 11th respondents. They have confirmed, even them, they were concerned. Why has the open display stopped? Why are you not announcing the results per constituency as you were doing before? That is what I'm saying my grandmother calls Nairobi Karafu. And my niece Mimi calls Piki Piki Ponki Pakamielo Disco. Because he called both of them. He called both of them. And he was the only person who knew who the disco would land on. It could have been either of them. It could have been William Ruto, it could have been Raila Odinga. It fell on William Ruto and he says, voila, you are the president. Is that how we intend to choose our national executive? We've reduced it to Mimi's childhood game of Piki Piki Ponki Pakamielo Disco.
Council again.
Yes, my lord.
I did give you brotherly advice. Be careful. That language appears to be alien to this court.
I'll be guided, my lord, I'll be guided. But the main point, so that we don't lose the crux of the point, is that the lack of transparency in the tallying and verification of the results, contrary to Article 10 of our Constitution, completely eroded public confidence in our Constitution. It completely left a very core exercise of a sovereign donation by the people to the whims of an individual not subject to any control. And that, my lords and my ladies, should not miss the attention of this court. My lords, in our submissions, we've spoken about the DCI report and the penetration of the system. Again, just to buttress the role of this chairperson. My lord, the DCI, as has been submitted, is set up as a government agency to investigate crime. They did find that indeed there were foreigners who had access to what we call critical election instruments. And their forensic report has established the presence of those persons. In other words, in layman's language, the DCI report has corroborated what the KPMG report has found and authorized users and access to critical elections technology. Should we ignore that and say, just look at the numbers, forget about the process? I humbly submit that we cannot now even focus on the numbers. We should not even, because the process through which those numbers are being arrived at has been compromised. So that anybody inviting you even to look at the number is inviting you down an alley, a process in which the wish of the people has been convoluted. My learned senior John Mohammed, representing a poor voter, did say that voter just wants to see, just wants to know, how was my vote converted into account and the result of the elections. If the infrastructure and the process set up for that poor voter does not guarantee integrity, then, my lords and my ladies, it is my humble submission that the number that an individual ultimately comes out with at the end does not matter. If that number comes out in a manner that infringes the Constitution, you've come up with your number in a manner that violates specific provisions of the Constitution, then that number does not matter. The Constitution has to be upheld. Because the Constitution is what established the framework through which we will start generating that number. You ignore the Constitution, then it doesn't matter. We've not organized ourselves as a sovereign on how to arrive at the number. My lords, as I move to conclude, I think it is very important that I buttress this point on the meaning of Article 138(3)(c), because I still have 4 more minutes and I will not wish to donate them at the moment, and Article 138(10). The IEBC shall tally and verify the count and declare the result. That's the first step. And I've invited the Honorable Court, there are numerous decisions from these courts on what a result is, outcome. So the first declaration to take ownership of the elections is done by the IEBC once they verified and tallied the count. And some of the tools of verification, number one are the KIMS kits, because the KIMS kits were meant to send you voter turnout per polling station. So part of how you verify, you ask yourself, this particular polling station, as per the KIMS kits, how many voters logged in? Thank you. How many voters logged in and voted in that polling station? Once you establish that, you check on the Form 34As, how many registered voters are entered to have voted in that station. If the numbers are different, then you ask for Form 32A, assuming some were identified manually. Those are the steps of verification. But if the numbers in your KIMS kits are less than the numbers of the votes returned and are not supported by any Forms 32As, then that's a polling station to be flagged. It means the verification has not returned or cleared that polling station. That is what the IEBC does. Verification is not, as they're trying to attempt to tell us, is about looking at the UV mark, looking at the serial number. Those are just part of verification. But the verification, number one, is to identify that indeed the true universe came out and voted. And that is very important. Once the commission satisfies itself, we go to Article 138(10), in which Article 138(10), the chairman now walks out of the commission meeting together with all his commissioners, if necessary, and proceeds to now declare the result. Because remember what I said, the first declaration was done by the IEBC when they concluded their verification and tallying. Then the other declaration, 138(10), is done by the chairperson. And then he issues the certificate as an individual. So that to assume that the chairperson on his own can conduct, or that the staff of the commission are the ones to do the tallying and verification, that is erroneous. It is the commission that does it. The staff of the commission are spread everywhere. They report to the commissioners who constitute the commission. And the commissioners take control of that process. And finally, my lords and my ladies, it is not the first time we are holding elections in this country. To say that Mr. Chebukati didn't know what the law was. He knew. These provisions have been applied in 2013. They were applied in 2017-1 and 2017-2. And the commission functioned as a commission to conduct those elections. Why should we now move away? My lords, finally, in this election, we submit the people had their say, but the machines, technology, had its way. Please correct it. Thank you very much. Have a good day.
Petition number 4 of 2022, David Kariuki Ngari.
My lady, this is petitioner number 5 in the consolidated petition. My name is Mituga. I will deal with issue number 6 as framed by the court. My colleague, Mr. Njiru Ndewa, will deal with issue number 8. The petition is dated 22nd of August 2022. We have filed submissions dated 25th of August.
Counsel, let us confirm. Who is your client?
My client is David Kariuki Ngari.
Ngari.
Yes.
Then according to our records, it's number 4, petition number 4.
I do apologize, my lord. It would appear I printed some ruling that reflected him as petitioner number 5
okay. Maybe
in the
after
consolidated petition.
After the consolidation, yes.
Yes.
The party is the same, no problem.
Very well, my lady. We have filed petitioner submissions dated 25th of August 2022. They are supplementary submissions dated 28th of August
Mr.
2022.
Mituga, sorry, you said that you'll address issue number?
I will address issue number 6.
And Mr.
Ndewa will address issue number 8.
Correct, thank you.
My lord, we have filed submissions dated 25th of August 2022. We have supplementary submissions dated 28th of August 2022. My lord, there is a quote attributed to the American statesman, Harry Truman, that the president, whoever he is, has to decide. He cannot pass the buck to anybody. No one else can do the deciding for him. This is his job. And my lord, it is my submission that constitutional mandates given to IEBC have to be performed by IEBC because the buck stops with the commission. Our constitution has been characterized as a transformative charter. My lord, the only way it can be a transformative charter is if we breathe life to it instead of paying lip service. The principles that run through the Constitution, including transparency, accountability, participation of the people, have to be given. We have to breathe life to those provisions if the Constitution has to live up to its characterization as a transformative charter. It can also live to its characterization as such if the independent institutions under the Constitution discharge their mandates according to what is provided there. One of the institutions is IEBC. Under Chapter 15 of the Constitution, it has a critical function which is captured under Article 249A. It must protect the sovereignty of the people. And one of the ways it protects the sovereignty of the people is to ensure that the will of the people in electing their representatives reflects what the people have voted it to be. This is because, my lord, sovereignty is exercised directly. It can also be exercised by the representatives they elect. So by sticking to the principles that guide the process of election, That's how it can give the sovereignty of the people the life it deserves. Under Article 81 and Article 86, the electoral process has to observe, among other principles, transparency. It also has to be an accountable process. My Lords, the Commission is constituted under Article 88, and the national legislation that provides for the Commission is the Independent Electoral and Boundary Commission, that is Act number 9 of 2011. Under Section 5, a commission is established, and under Section 11 and 11A, it's categorical that the Secretariat works under the Commission. So the staff of the Commission performs a delegated function. The buck stops with the Commission. My plain reading of Article 138(3)(c) is that the process of tallying, verification, and declaration of the result is the mandate of the Commission. It's not the mandate of the staff or the Secretariat. This is also reiterated under Section 39, 1C, paragraph B, which also states categorically that the function of tallying and verification is supposed to be done by the Commission. Was it done by the Commission? That is the only question, my Lord, I will answer. I will answer it through the eyes of the averments made by the 9th respondent, that is Professor Abdi Gulier, and the 4th respondent, that's in the consolidated petition, that's Honorable the Chairman Chebukati. This is how, from their own affidavit, without even going to the regulations in which they set out on how the verification was supposed to be done, from their own affidavits. When the other 4 commissioners are clear that they were not involved in the verification and tallying and declaration of the result, this is what they say in their respective affidavits. The affidavit of Professor Gulier, the 9th respondent, sworn on 20th of August 2022 in respect of petition 005, at paragraph 8, he is clear that once assigned a responsibility by the Commission, whatever recommendations he makes have to go back to the Commission for consideration. So from his own averment, it was clear that even when the Commission delegates a function to a commissioner, he has to report back to the Commission for approval. At paragraph 32 of his affidavit, this is how he described how verification was done and the result generated. That the Chief Executive Officer / the Commission Secretary came with the final result. That is on 15th of August 2022, when the commissioners were seated in a meeting. He acknowledges that the verification is not being done by the Commission. It is the Chief Executive Officer getting to the commissioners a result, a clear admission that they were not involved in the tallying and the verification of the result. Now, in respect of the 27 constituencies which have been mentioned, and there was doubt whether verification was done, This is how he puts it in paragraph 27, paragraph 35 of this affidavit, that these constituencies were verified in the presence of agents of candidates and included in the final tally. There's nowhere in that statement it says that verification was done by the Commission. Now, on why he did not even announce the result for transparency, then he says there was no calmness in the auditorium for them to announce the result. But then the question is, when it was restored, the chairman of the Electoral Commission was able to read the result in Form 34C. The question is, during that period, how is it that they could not read the result for the 27 constituencies? The chairman of the commission, Honorable Chebukati, in his replying affidavit to the fourth petitioner's petition, the affidavit is undated, but it was filed on 27th of August 2022. This is how he characterizes the verification of the result by the commission. At paragraph 31, he avers under oath that the verification and tallying was undertaken by a staff of IEBC with some commissioners assigned the role. My Lord, from the chairman's own averment, the verification is being done by a commissioner assigned the role, and the staff of IEBC. There is no indication anywhere that that outcome of the verification was brought before the commissioners before an announcement was made. It is understandable that tallying and a verification of over 40,000 polling stations is an Herculean task, and it cannot be done by 7 commissioners. But, my lords, if they delegate that function to the staff of IEBC and a commissioner or 2 commissioners, it is my submission that whatever report that comes out of that tallying and verification has to be placed before the commissioners before a declaration is made. My Lord, that was not done. Now, an explanation is given by the chairman of the commission at paragraph 25 of his affidavit in reply to the fourth petitioner's petition, when the fourth petitioner avers that no announcement was made for 27 other constituencies for purposes of transparency, this is what he responds: there was no legal obligation to do that. My Lord, there is no explanation given why it was done in respect of 261 other constituencies and not the 27 constituencies. It's my submission that in respect of those other 27 constituencies, there was lack of transparency and accountability. The chairman avers in that paragraph 25 of his affidavit further that Professor Gulier was prevented from reading the results, but there's no explanation further why he could not read the result for the 27 constituencies after calm was restored. And if at all tallying was already done for the 27 constituencies and a report prepared, my lords, this should have been included in the reply of the chairman to the petition to confirm that indeed the tallying and the verification had already been done. It's my final submission that the result that was declared by the chairman of the commission did not reflect the will of Kenyans, and it should not be let to stand. My colleague will take over the issue number 8. Thank you, my lord.
My ladies, my lords, my name is Dego Anjiru, permit me to address issue number 8 in respect to our petition. And while addressing that issue, my ladies, my lords, I'll be seeking to answer the question whether or not the election that was conducted on 9th of August was a constitutional election. While I do that, my ladies, my lords, permit me to refer you to various affidavits, and I begin by referring to paragraph 52, paragraph 53, and paragraph 54 of our petition. I'll also refer to paragraph 51 of the Vice Chair's replying affidavit, that's the 5th respondent. I'll also refer to paragraph 25 of the Chairman's Chebukati's replying affidavit. I'll finally look at paragraph 19 of the second respondent's, William Samoei Ruto's affidavit. Why are these paragraphs important to these proceedings, my ladies, my lords? And while addressing that question, I am going to refer to various provisions of the Constitution. I'll begin by referring to Article 88 of the Constitution. I'll seek reliance again on Article 89, Article 97, Article 138, Clause 2. I'll also seek reliance on Section 2 of the Election Act, and I'll also seek reliance on Section 83 of the Election Act. My ladies, my lords, if you look at the affidavits that I have mentioned, and most importantly, affidavit by the chairman of the commission, at paragraph 25, he defines and says that he conducted tallying of election results in 291 constituencies. Paragraph 19 of Honorable William Ruto's affidavit, again he says that elections were conducted in 291 constituencies. The fundamental questions, my ladies, my lords, is how many constituencies do we have in this republic? If you look at Article 138, Clause 2, the Constitution provides that elections shall take place in each and every constituency in this Kenya. And when you define constituency, my ladies, my lords, you look at the provision of Article 4 and Article 5. Article 5 of the Constitution, which defines the territory of the Republic of Kenya. Then you further look at Article 89, Clause 1. It says there shall be 290 constituencies in the Republic of Kenya. And that is where the law contemplates that elections shall take place. But what happened on 9th of August is that we have submissions and averments that elections took place in 291 constituencies. The fundamental questions, my ladies, my lord, is where did this extra constituency come from? And is this extra constituency a constitutional constituency defined by the armpits of Article 89? There may be arguments that this was a constituency by the diaspora. Yes, they may have their rights under Article 38 to vote. But the question is it a constituency within the meaning of the law? We submit that to the extent that individuals not confined to Article 89 of the Constitution, to the extent that the elections of an extra constituency not defined under Article 97 took place during that particular time, that contaminated the election. You must then ask yourself, to what extent was the contamination? Article 138, Clause 4 requires the Commission to compute whether or not the president-elect has attained 50 plus 1%. We are submitting that these elections that took place in alien constituencies contributed to the computation of 50 plus 1%. Then you might ask yourself, my ladies, my lords, what then is the test that I'm trying to apply? I am applying the test proposed by Section 83 of the Constitution of the Election Act. It provides that an election can be voided if that election did not comply with the Constitution or other written law. And this is a fundamental question, my ladies, my lords, because a constituency as defined by Article 289, Article 89, that must be within the territory of Kenya as defined by Article 5, then contemplates a situation whereby there is a question of representation. It subjects the people of Kenya to exercising their sovereignty through the representation of those people. The question then that begs an answer is, how can an election that has been infiltrated by alien constituencies be regarded as a constitutional election? We submit thus that waives the fundamental requirement where IBC under Article 88, Clause 5, is required to conduct an election within the armpits of the Constitution. It is a mandate within the IBC that the mandate is so fundamental that it cannot be waived, it cannot be fettered, it cannot even be relaxed. An individual cannot create a constituency. If it was in the interest of Kenyans, while promulgating this constitution and adopting this constitution and giving this constitution unto themselves to create an extra constituency, there was nothing that was as easy as saying as such. My ladies, my lords, permit me to address the question of the 27 constituencies. Again, it has been submitted by my learned friend that under paragraph 25 of the Chairman Chebukati's replying affidavit, he has glossed over that weighty issue. He does not consider that 27 constituencies, which makes about 10% of the Kenyan constituencies, which translates to about 1.9 elected voters, were not included in the final tally. And what does he do? He makes and he amends and carefully uses the words which to apply. In his replying affidavit, he technically avoids the use of the word declaration and he uses the word announcement. The word announcement is not akin, is not similar, and does not mean declaration. Why, my ladies, my lords? Because Article 138, Clause 4, presupposes a declaration of all the polling results by the IEBC. So this declaration is not akin to announcement. And therefore, my ladies, my lords, we are submitting that the chairman of the Electoral Commission was lost on what he needed to do. He is making a declaration and reducing the question of declaration to the question of a master of ceremony. The IBC chairman was not called upon to just officiate the process. He was called upon to execute a constitutional obligation. And therefore, when the law speaks about a declaration, there must be clear demonstration that the same was done. What happened, my ladies, my lords? He says that the law does not require him to do so. He does not annex any evidence that the same was declared. He does not annex any evidence in his affidavit that there was tallying. He does not aid this honorable court to make an opinion that, yes, the requirements of the Constitution were met. Finally, my ladies, my lords, we need to interrogate the conduct of the chairman of the IBC. We need to interrogate the previous and even the current conduct of the chairman. He was effectively described by my senior line friend, Mr. Norji, that is a person who has perfected the art of imperfection. And he has perfected the art of imperfection by making sure that he conducts a lone ranger process. Remember, my ladies, my lords, to the run-up of the second election in 2017, a similar issue arose, which necessitated the resignation of the commissioners. How long shall we allow an individual to keep on transgressing the law? How long shall we allow this individual to keep on putting Kenyans and to subject Kenyans into uncertainty? The law requires that there must be certainty. And the certainty contemplated by the law is that I shall cast my vote, and my vote shall count. And why are the 27 constituencies fundamental and key to these proceedings? If you look at our paragraph 57, 52, 53, and 54, we have listed those constituencies. It is where an individual or the first petitioner has his supporters. It is where he has his support base. So were they left out as a matter of design? Were they left out by default? Or was he holding someone's brief? My ladies, my lords, we submit that to the extent that those constituencies were not tallied, were not verified, and the declarations were not made, then this election did not meet the provisions of the Constitution. Finally, my ladies, my lords, he says in paragraph 25 that he can announce elections anytime that he so wishes, even if there are some constituencies that have not generated their results. But what does section 39, subsection 2 of the Election Act provides? It provides, my ladies, my lords, I would wish to read this. The chairman may declare a candidate elected as president before all constituencies have transmitted their results. The operating word here, my ladies, my lords, is the word before. So if before, at the time he's declaring those elections, the constituencies have not generated their results, he can declare. But the situation where we are in, my ladies, my lords, on 9th, going by the dictates of Maina Kiai's case, the chairman had received all the results from the polling stations. It was therefore incumbent upon him to make sure that they are included, to make sure that they are tallied, to make sure that they are verified. Finally, my ladies, my lords, permit me to delve on an issue that was dealt with in the morning by my senior learned friend, Mr. Governor Orengo. My ladies, my lords, I am referring to the replying affidavit filed by Honorable William Ruto, and I'm referring to page 111, where it indicates a preliminary statement of the IGAD election observation mission to the August elections. At that paragraph, my ladies, my lords, these were individuals who are observers of the elections, who are out there observing the elections. When it came to the question of analyzing the voters' turnout, the report says, it is annexed in its affidavit, that in most of the polling stations visited, voters' turnout was noticeably low and recorded around 55%. Those were observers out there in the field observing the elections, giving a return of the 55%. And this 55%, and you can see how this computation of the turnout is fluid. It is so fluid, it's a lever. You are not able to hold it. The chairman is not able to tell about the voters' turnout. The report is giving us a different voters' turnout. So what exactly was the voters' turnout? So that the voters' turnout then can assist us in the computation of the sum of 50 plus 1%. Finally, my ladies, my lords, there's a question as to the computation of the 50 plus 1%. That when the chairman gave his final public address about the voters' turnout, he deliberately exempted those individuals who voted manually. To date, we are not aware of how many people passed through the manual registration? How many people voted manually? I mean, my ladies, my lords, it is not within the armpits or within the purview or within the power or the discretion of the chairman of the Electoral Commission to do that what he wishes. He cannot deal with the question of elections from his aspirations or from his wishes. He must deal with the question of election as dictated by the Constitution, as dictated by the election laws. Finally, my ladies, my lords, we urge you to admit our petition and you dismiss the replies filed by all the respondents and find that this election was not conducted in accordance to the Constitution. And my ladies, my lords, that you give an order that the sovereignty of the people must be respected. And the sovereignty of the people cannot be respected, cannot be upheld where there is serious transgression at the wishes of the chairman of the Electoral Commission. Finally, my ladies, my lords, there needs to be a retribution. There needs to be a stop of all these transgressions. How many times shall we subject Kenyans to these processes? How many times should we appear before you with the same grievance every day, after every elections? There ought to be a stop. And a stop is making sure that the proper sanctions, criminal sanctions, as prescribed by the Election Act, are meted against any transgressor. And there is no one who is above the law, including the chairman, so that people may learn to respect the law. I'm so obliged. I donate the 26 minutes to the court.
Thank you very much.
Seconds.
Those are seconds. Thank you very much, Council. As regards petition number 7, we have Mr. Mtata appearing for himself, and Professor is appearing for the other. So I think you'll share the time, Prof.
Yes, thank you, Your Ladyship. Well, our submissions will be in two parts. The first part will be qualitative, and I will address myself to the law and complement the submissions that have been made by learned friend, Senior Counsel James Orengo, learned friend, Senior Counsel Philip Murgor and Feroz Noroji, on the questions of compliance with the law and on the unconstitutional nature and the non-compliant nature that the first respondent, Mr. Chebukati, employed in running the presidential election of 9th August 2022. My lords, the person I do not want to be now is Professor Githu Muigai, because every single advocate in this court has spoken to the violations by his client. Violations, my lords, that border on the violation and speak to the violation of Article 3.2, the unconstitutional proceedings that led to the issuance of Gazette Notice 9773 of 2022, issued on 16th August 2022, that declared the president-elect. My lords, we shall be asking that violation or that Gazette Notice be vacated as we make several orders, my lords, under Section 84 of the Elections Act and Article 143 of the Constitution. My lords and my ladies, let me start by submitting that my submission shall be around one, the issues framed by the court, particularly, my lords, issue number 8 on illegalities and irregularities that, if applied disjunctively as this court has ordained before, my lords, will lead to a compelling order of nullification of the elections of 9th of August 2022. But I will also, my lords, and in view of the powers of this court under Section 3 of the Supreme Court Act, delve into the interpretation of Article 143. And, my lord, perhaps because this court is also the jurisprudential head of the judiciary, to see, my lords, whether there are possible sanctions or possible findings that this court can make other than the order of nullification. And my lord, that will be in my last submission. My lord, let me just touch on the second part. The second part that my learned friend Mr. Omtata will deal with will be the maths, electromaths, the mathematics of the election. We will demonstrate by way of a PowerPoint presentation that none of the candidates met the 50% plus one vote as per the tallies that were read by Chairman Chebukati on the percentages weighed against the voter turnout and the votes cast, my lords. And that will show that if indeed no candidate attained the 50% plus one, then this court has a daunting task. One, of course, after the exercise that is ongoing, the exercise that is going on with the server, my lords, we will be asking this court, my lord, to think of the possibility of declaring a winner after the outcome of the